The Supreme Court today dismissed Louisiana's appeal seeking to prevent the state's congressional map from being redrawn over claims that it unlawfully dilutes the influence of Black voters. The move via a brief unsigned order was expected after the Supreme Court's ruling on June 8th that buttressed a key part of the landmark Voting Rights Act in a similar case concerning congressional districts in Alabama. Black voters in Louisiana are roughly 1/3 of the state's population, yet the state's legislature originally enacted a congressional map that allows Black voters to elect a candidate of their choice in just 1 out of 6 total districts. Gerrymandering is denying them fair representation, but that is about to change. There was a brief rebellion in Russia on Saturday. The leader of a powerful mercenary group sent his troops marching towards Moscow, seizing a major military base and key installations along the way. Tensions between the mercenary leader and Russia's military leaders have been building for months over decisions about the war in the Ukraine. The troops turned around after a deal was brokered by Belarus. But this was a stunning challenge to President Vladimir Putin's authority and, according to some, could weaken him forever. The Kremlin scrambled today to project control after the dramatic armed rebellion posed the biggest challenge to Vladimir Putin in more than 20 years of rule. This year, murders have fallen by more than 12% in major cities after also having fallen slightly last year. The murder rate is still about 10% higher than it was in 2019, but at least the trend is going in the right direction. The declines are a sign that at least 2 of the issues that likely contributed to the murder spike, COVID-19 and the fallout from George Floyd's murder, are receding. Well, the Coast Guard opened an investigation today into the deadly sub accident. The submersible imploded last week during an expedition to the Titanic wreck in the North Atlantic, killing all 5 passengers. Investigators are looking into the cause of the implosion, and the findings could lead to new diving regulations or possible criminal charges. Well, we can all expect a busy week from the Supreme Court as it wraps up its term for the summer. It still needs to release decisions on many big cases, including affirmative action and President Biden's student loan program. Justices handed down a ruling on immigration, though, that allows the White House to continue setting deportation priorities. The next big decision day is tomorrow, and we will be tracking what the Supreme Court does on those big cases, and we'll be here with you from 4 to 6 with expert analysis on those decisions. Joe Biden today is announcing that $42 billion is going to be expended to expand high-speed internet access nationwide. Now, this is commencing the federal push to help an estimated 8.5 million families and small businesses finally take advantage of modern-day connectivity. In a speech on Saturday, marking the anniversary of the Supreme Court's reversal of Roe v. Wade, Vice President Kamala Harris condemned conservative justices for creating what she called a healthcare crisis in
Access granted.
In a survey conducted by the public opinion research firm Eviderus, KBLA Talk 1580 consistently emerged as the station of choice for Black audiences in the Los Angeles media market and beyond. The survey also revealed that the vast majority of Black audiences are concerned about the lack of Black-owned media and are more likely to listen to talk radio that focuses on issues that impact the Black community. For some reason, the other talk stations haven't quite figured that out.
If you think about KFI, well, KFI only has like a 3% Black listenership. 3%. So there's a good 97% out there to support a station like KBLA.
At KBLA Talk 1580, we've got your Black. Your Black. Your Black.
Follow the leader.
KBLA Talk 1580.
Follow the leader.
Be sure to follow us on Instagram at KBLA 1580.
Follow the leader.
Are you ready?
The station leading the way with exclusive interviews,
Follow the leader.
stimulating conversation, and intellectual discourse that empowers, enlightens, and informs.
Follow the leader.
Follow the leader at KBLA 1580. We've got a lot to talk about.
Keep following the leader.
Follow the leader. Follow the leader. Follow the leader. Follow the leader. Follow the leader.
Gotta stay fresh, ma. House shot with a rest bar. Shot with a rest bar. Shot with a rest bar.
Have you visited us online for the grand opening of KBLA.store? For the best in new merch, gift ideas, books, media, and more, log on to KBLA.store. Be sure to check out our KBLA team favorites at KBLA.store today. That's KBLA.store for all the official merch on your favorite talk radio station, KBLA Talk 1580.
The bounce is back.
Here comes the brand new flavor in your head.
Race, social justice, sports, politics, art, music, culture. We do it all on the D.L. Hughley Afternoon Show. If you're not tuning in, then you are definitely missing out. It's the D.L. Hughley Afternoon Show, weekdays from 2 to 4 only on unapologetically progressive KBLA Talk 1580.
Like a brand new flavor in your head. Yeah.
This is a rather bold pronouncement, but we think we can back it up. If you come across a radio frequency anywhere putting more variety and more diversity on the air than KBLA Talk 1580, we sure would like to hear about your discovery.
You got to have vision.
You can search, but we are confident that you won't find more shows covering more topics, hosted by a more diverse and inclusive lineup of talkers than the squad we have assembled here at KBLA Talk 1580.
This is the time, brothers. This is the time.
We've got something for everybody.
That's right.
Health and healing, history and humor, issues and events, empowerment and entertainment, all in one station.
What's really going on?
Free enterprise, you dig?
KBLA Talk 1580.
Yes.
Oh yeah. We got a lot to talk about.
King Kong ain't got on me.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out. Everybody wants to talk to Tavis.
That's one reason, by the way, why I'm so thrilled to have this conversation with you today. The three people I always most hoped would interview me were Phil Donahue, Studs Terkel, and Tavis Smiley. Donahue's retired, Terkel's deceased, so this is a real thrill for me. And the reason why I have such respect for what you do is you have a historically informed conversation of depth and detail.
Be sure to tune in to Tavis Smiley weekday mornings, 9 a.m. to 12 noon on your unapologetically progressive radio station, KBLA Talk 1580. KBLA Talk 1580.
Is the pen mightier than the sword?
They say the pen is mightier than the sword. At KBLA Talk 1580, we not only have a lot to talk about, we have a lot to write about. Politics, relationships, business, empowerment, and culture. The all-star roster at KBLA Talk 1580 has you covered.
That's what it's all about.
Be sure to follow us on all our socials for our latest book releases, op-eds, essays, and commentaries from our hosts. And, of course, download the KBLA 1580 app as we strive to remain your most trusted, credible.
This is Areva Martin in real time, and I'm your host, Areva Martin. And this is the second hour of the show where we go deep on those stories that everyone is talking about. And today, that's what happened in that federal courthouse in downtown Los Angeles today in the federal bribery trial of Mark Ridley Thomas. We know that there were some important motions filed by the MRT team, the Mark Ridley Thomas team, and there was some argument made before the judge by that legal team and some opposition from the prosecution. KBLA's own justice correspondent, Dion Raymond, was in the courthouse this morning, along with what looked like to be another 75 to 100 supporters of Mark Ridley Thomas who packed that courthouse in their show of support. Dion is here along with our legal expert panel, Bobby Grace, veteran prosecutor, and Mansfield Collins, a federal criminal defense attorney, and they are going to help us break down what these motions mean, what's next in this case. So welcome, Dion, Bobby, and Mansfield. I want to start with you, Dion. Take us inside that courtroom today. Tell us who was there, what was done, and what's your take on what you saw this morning?
Thank you, Areva, and it's always a pleasure to be here. This morning, the motions that were filed by the defense, motions for acquittal and motions for a new trial. And as everyone here knows, but maybe those who are listening may not know, is that motions were filed and well in advance of today's court appearance, giving the judge an opportunity to read those papers and hear what each side has to say in writing, particularly as it concerns the law. And so as my mentor, Johnny Cochran, used to say, a lot of things are usually decided on the papers before a lawyer even walks into that courtroom. And so today was the opportunity for both sides, Ariva, to highlight the points and their arguments that are already in those papers. And so I'll just highlight some of the things that were said today in court. But before I even get to that, I just want to give you guys kind of a feel really quickly of what the atmosphere was like. The hearing was at 10 o'clock. When I arrived at around 8:15, there were at least 50 to 60 people already in front of Dale Fisher's courtroom. I mean, pressed against the door, not literally, but there, very professionally, very peacefully, just waiting to go in. And when the courtroom opened, the judge came out and she said, I know a lot of you are here for the 10 o'clock hearing. You don't have to stay here. No one moved. The whole courtroom was full. It was so full that they opened up the jury box for individuals there who are lawyers, who were there who had business on record, and those who didn't. So it was very well attended, and people were very interested and very attentive. And so the main thing that was highlighted by the defense who brought these moving papers was, and let me just kind of recap, there were counts 4 through 20 alleged that Dr. Mark Ridley Thomas and Marilyn Flynn engaged in a scheme to defraud the residents of LA County of honest services. And so one of the things that the defense highlighted was that, where is this official act that was taken by Dr. Ridley Thomas? Because a lot of the conversation today, or the argument, centered around a telehealth contract that was already in place. And it was on a consent calendar to extend the life of the contract, not the amount of the contract, but the life of the contract. And so what they highlighted was because it was on the consent calendar, it didn't require Dr. Ridley Thomas to do anything. And that essentially what the government had done was put him in a position to infer to the jury that, was he supposed to do something affirmative? Was he supposed to object to it being on calendar or do something to stop it? And that he has no affirmative duty to do that. Also, they highlighted the issue of whether or not he did, with regards to a fiduciary duty, meaning that he had a duty to the public in his official capacity. And what was this fiduciary duty that he broke? And so what they highlighted for the court was that the government, their position is that the government never brought any evidence to show a breach of that fiduciary duty, any requirements to make disclosures or anything like that. And what they hammered on was that these types of things are public and on the website, and that the government never put this in front of the jury. Another thing that they talked about today was the issue of quid pro quo. That's where you do something, I do this for you, you do this for me. And the argument was that there was no evidence put forth that there was any quid pro quo on Dr. Ridley Thomas's part in order to vote for this extension of the telehealth contract. The government brought forth the vice dean of the program, Marilyn Flynn's vice dean, who testified that after the telehealth contract extension was approved, that John Clapp testified that Marilyn Flynn said it was approved, but I had to do a favor for it, and winked. What the defense argued was that there was no evidence saying what that favor was or from whom. And so, of course, the government, their position is that this contract is, quote, the clearest, most dispositive evidence of this scheme, because even though he didn't have to say or do anything, that it effected a yes vote. So that's pretty much a recap of the defense's side.
Yeah, let me stop you there, because I want to ask Bobby, our veteran prosecutor, about this theory. Essentially, what the defense argued was that the prosecution offered up a theory of omission, that Mark Ridley Thomas should have stopped a consent vote from happening and somehow raised his hand. And they're saying that alone is sufficient to constitute an official act. What's your take on that theory of action by omission being an official act, Bobby?
Ariva, good afternoon. Thanks for having us again. I believe, and Dion's kind of alluding to this, that they're convoluting two things. Omission, meaning that Dr. Thomas had a fiduciary duty to tell the public that he had a conflict of interest with respect to his son, Sebastian Ridley Thomas, and his relationship with USC. In other words, Dion, when you were referring to the wink, that's what they're talking about, like that Sebastian Ridley Thomas got into USC and that this money was funneled through the University of California. So those are the things that they're talking about, that he had a duty to let people know that he had this conflict of interest and abstain from voting. That's what I'm surmising from it.
I think what they're saying is that, so what the defense argued was there was never an affirmative vote, that Mark Ridley Thomas never voted for the extension of the telehealth contract, that the telehealth contract extension went on the consent calendar for the county. And what's consent calendar means nobody did or said anything. It's just kind of automatically approved. And the defense attorney is saying that the government is making this act of omission, trying to equate that with an official act. And the defense is saying that's not an official act.
Right, and that's the tough part here. That's the matter that is in conflict here. Did MRT did he do something that would equate to a corrupt act, something that was wrong? That's what this whole trial is about. That's what it really boils down to.
I'm just trying to narrow down to this theory of omission. Maybe Mansfield, you can jump in here. Is the no vote, the consent calendar vote, that process of how things get approved at the county by consent, where nobody has to say yay or nay, is that sufficient to establish an official act?
I don't think so under these factual circumstances. For example, someone may be sick the day of a consent vote, or the day that an item appears on a consent calendar. If he's sick, why would he have to go to the office and cast a vote? He may be sick. He may have a legitimate reason why there was no statement put on the record one way or the other. But this seems to be a case that is really stretching the concept of honest services and corrupt intent to a category of conduct that will basically catch all politicians or all individuals, because it's just too large of a net that the prosecution is casting here. No, I don't think the facts in this case support any kind of duty that someone would have to object to something that's on a consent calendar, because you first have to establish that conduct in and of itself indicates a criminal intent. I don't see the matchup between an accusation that Mark Ridley Thomas had a criminal intent, and that's why he didn't take an affirmative action by trying to object to something that was on the consent calendar. That is such a stretch. There's so many hurdles that they have to go through to get to that conclusion. No, I don't think that's a solid argument for the prosecution at all.
And Bobby, let me ask you this. We know that the prosecution, they didn't put on any county employees. They didn't put on any case to try to establish how matters get voted on, what a consent calendar is, what a consent calendar vote means, what it doesn't mean. That was pretty much, I guess, left for the jurors to surmise. Is there a problem from your perspective with that there was no explanation? Because we're sitting here talking about consent calendar without really explaining either, because you probably have to work inside the county to have a clear understanding of what that even means. So if four of us, four lawyers, we haven't yet given a clear definition of it. what are the jurors thinking when they keep hearing this consent calendar?
Well, again, Ariba, I think that's the whole problem with this particular prosecution, is that there was so much smoke that was kind of produced by the prosecution as to what it might prove that didn't actually get proven in court. And as we go forward, it's going to be interesting to see whether the judge agrees with Mansfield's take on this with respect to honest services. But as we talked about the last time that we were together, there's a big issue with respect to the Supreme Court's take on these honest services contract. And so even if the conviction survives here, I would be very surprised if this doesn't get overturned on appeal, because some of the cases that the Supreme Court has taken up in the last year or so, it shows that they have a very, very negative view of this whole honest services theory of conviction.
Can I just
interject? I'm glad you brought that up. Hold on. I just want to make sure that the audience understands the importance of what Bobby just said. This was not an appeal today. It gets a little complicated, but these were motions that were filed and heard and argued before the same judge that tried the case. And once there is a conviction, the person convicted gets to file motions asking that same judge that presided over the trial to, in this case, throw out the conviction. Essentially, that's what the motions were asking the court to do, or in the alternative, to grant a new trial. Now, again, this is not the appellate process. This is post-trial motions filed before the same judge. So the same judge that presided over the trial will be making determinations about these motions. And if the defense, i.e. Mark Ridley Thomas's team, is not successful at this juncture, they still have the ability to file an appeal before the Ninth Circuit Court of Appeals to have these same issues heard. And as Bobby talked about, the appellate courts and the Supreme Court have a real interesting take on these honest service cases and convictions under these federal statutes. And according to Bobby, those cases are much, much more favorable to Mark Ridley Thomas and the set of facts here once this case, and if this case gets to that appellate stage. Go ahead, Mansfield.
Just to dovetail what you and Bobby have been saying, the McDonald's case is the Supreme Court case dealing with honest services, and it concluded that it takes an affirmative action, an affirmative act on the part of a defendant to come within honest services. And so now when we're talking about an act by omission, that just goes completely contrary to the ruling held in the Supreme Court decision in Virginia versus McDonald, the People versus McDonald.
Now let me just if I can, Ariva, just weigh in and give this to Mansfield and Bobby and you as well. What the government argues is that, also their feeling is that collectively, and I'm summarizing, that MRT and Marilyn Flynn had discussions about county business, about this gift of money, that and then things started happening, that he made a phone call to the director of DMH, John Sharon, to link him with Marilyn Flynn, that things started happening afterwards. And so that there were affirmative things that were happening. There's an email that says, "Your wish is my command," and things like that. So that's the part that's, that's from the government.
Yeah, and we're going to talk about that when we come forward. Also, we're going to talk about the prosecution's claim that Mark Ridley Thomas forced the other supervisors to support the extension of the contract, because we know, Deanna, you were in that courtroom. The FBI agent said on the record that he didn't know what the consent calendar was or how it worked, and there was never any testimony about Mark Ridley Thomas forcing anyone to do anything, because the prosecution never called anyone from the county. And of course, the witnesses from the county that testified in Mark Ridley Thomas's defense definitely never testified that he forced anyone to do anything. So we're going to talk about what all of that means as the judge again weighs these motions. Something I want to remind our listeners and viewers about. If you are the second caller right now, if you call KBLA right now, you're the second caller, you can win a KBLA Talk 1580 swag bag. It's our gift to you as we celebrate our second anniversary at KBLA Talk 1580. Congratulations to that caller number 2. Right now, we are waiting to hear from you. Your friends at KBLA Talk 1580 want to bless you. That's 1-800-950-1580. Give us a call right now. We want to bless you with a swag bag. When we come forward, more with my legal experts and their take on what happened in the courtroom today, what these motions mean for Mark Ridley Thomas, and what's next in this case. Stay with us, KBLA Talk 1580.
Follow the leader.
KBLA Talk 1580.
Follow the leader.
Be sure to follow us on Instagram at KBLA 1580.
Follow the leader.
Are you ready?
The station leading the way with exclusive interviews,
Follow the leader.
stimulating conversation, and intellectual discourse that empowers, enlightens, and informs.
Follow the leader.
Follow the leader at KBLA 1580. We've got a lot to talk about.
Keep following the leader.
Follow the leader. Follow the leader. Follow the leader. Follow the leader. Follow the leader.
Gotta stay fresh, my house shot with a rest bar, shot with a rest bar, shot with a rest bar.
Have you visited us online for the grand opening of KBLA.store? For the best in new merch, gift ideas, books, media, and more, log on to KBLA.store. Be sure to check out our KBLA team favorites at KBLA.store today. That's KBLA.store for all the official merch on your favorite talk radio station, KBLA Talk 1580.
The bounce is back.
Here comes the brand new flavor in your head.
Race, social justice, sports, politics, art, music, culture. We do it all on the D.L. Hughley Afternoon Show. If you're not tuning in, then you are definitely missing out. It's the D.L. Hughley Afternoon Show, weekdays from 2 to 4 only on unapologetically progressive KBLA Talk 1580.
Like a brand new flavor in your head.
This is a rather bold pronouncement, but we think we can back it up. If you come across a radio frequency anywhere putting more variety and more diversity on the air than KBLA Talk 1580, we sure would like to hear about your discovery.
You got to have vision.
You can search, but we are confident that you won't find more shows covering more topics, hosted by a more diverse and inclusive lineup of talkers than the squad we have assembled here at KBLA Talk 1580.
This is the time, brothers. This is the time.
We've got something for everybody.
That's right.
Health and healing, history and humor, issues and events, empowerment and entertainment, all in one station.
What's really going on?
Free enterprise, you dig?
KBLA Talk 1580.
Yes.
Oh yeah. We got a lot to talk about.
King Kong ain't got on me.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out. Everybody wants to talk to Tavis.
That's one reason, by the way, why I'm so thrilled to have this conversation with you today. The 3 people I always most hoped would interview me were Phil Donahue, Studs Terkel, and Tavis Smiley. Donahue's retired, Terkel's deceased, so this is a real thrill for me. And the reason why I have such respect for what you do is you have a historically informed conversation of depth and detail.
Be sure to tune in to Tavis Smiley weekday mornings, 9 a.m. to 12 noon on your unapologetically progressive radio station, KBLA Talk 1580. KBLA Talk 1580.
Is the pen mightier than the sword?
They say the pen is mightier than the sword. At KBLA Talk 1580, we not only have a lot to talk about, we have a lot to write about. Politics, relationships, business, empowerment, and culture. The all-star roster at KBLA Talk 1580 has you covered.
That's what it's all about.
Be sure to follow us on all our socials for our latest book releases, op-eds, essays, and commentaries from our hosts. And, of course, download the KBLA 1580 app as we strive to remain your most trusted, credible, and reliable source for the issues you care about. This is unapologetically progressive. KBLA Talk 1580.
What up, baby?
Tell me I'm the boy that girl. I'm young, gifted, and black.
At KBLA Talk 1580,
we do more than just talk.
Hey there, I'm Jared Hill, president of the National Association of Black Journalists of Los Angeles, and I just want to say thank you for the benevolent $10,000 donation and scholarships for the next generation of Black journalists.
And I'm Haywood Galbraith, photojournalist and founder of the Minority Photojournalism Institute. Thanks, KBLA, for your generous $10,000 scholarship gift to help us train the next generation of Black photojournalists.
Congratulations to all the students who will benefit from the scholarship dollars raised at our Black History Month luncheon, honoring Black legends in LA media. When we come forward at KBLA Talk 1580, we're bringing everybody with us. Everybody with us. Everybody with us. Everybody with us.
Access granted.
In a survey conducted by the public opinion research firm Eviderus, KBLA Talk 1580 consistently emerged as the station of choice for Black audiences in the Los Angeles media market and beyond. The survey also revealed that the vast majority of Black audiences are concerned about the lack of Black-owned media and are more likely to listen to talk radio that focuses on issues that impact the Black community. For some reason, the other talk stations haven't quite figured that out.
If you think about KFI, well, KFI only has like a 3% Black listenership. 3%. So there's a good 97% out there to support a station like KBLA.
At KBLA Talk 1580, we've got your Black. Your Black. Your Black.
Follow the leader.
KBLA Talk 1580.
Follow the leader.
Be sure to follow us on Instagram at KBLA 1580.
Follow the leader.
Are you ready?
The station leading the way with exclusive interviews,
Follow the leader.
stimulating conversation, and intellectual discourse that empowers, enlightens, and informs.
Follow the leader.
Follow the leader at KBLA 1580.
We've got a lot to talk about.
Keep following the leader.
Follow the
I am back, and this is Areva Martin in real time, and I'm your host, Areva Martin, and I am joined by our legal panel, Dion Raymond. She is the KBLA Justice Correspondent. We have veteran prosecutor Bobby Grace and federal criminal defense attorney Mansfield Collins is here. We're talking about what happened downtown in that federal courthouse in the ongoing case of Mark Ridley Thomas. You know, he was indicted on 7 counts of a 19-count indictment. Just want to make a couple of notes that I think are important. Dion, you mentioned that before 10 a.m. there was a huge crowd already outside that courthouse trying to get in. I know some folks in the news said most of those folks were staffers and other folks close to Mark Ridley Thomas. They failed to mention, though, that was a cross-section of the Los Angeles community that was actually out in support of him. And by some accounts, it was as many as 75 to 100 people who showed up for the hearings this morning. I also want to note that 12 counts involved in that 19-count indictment. Mark Ridley Thomas was actually acquitted on 12 counts. And those 12 counts were the counts that involved his son, Sebastian Ridley Thomas, and the government's claim that Mark Ridley Thomas engaged in conduct, i.e. gave or extended a contract to USC in exchange for his son getting a job and a scholarship. There was a finding of acquittal on all of those charges related to Sebastian Ridley Thomas. So when the media writes about this case, we got to hold them accountable and make sure that they are not continuing to soundbite it and to summarize it in a way to suggest that Mark Ridley Thomas was convicted for some quid pro quo related to his son, because that is just not accurate. He was indicted on the counts involving honest service mail wire fraud related to his wiring of $100,000 from a campaign account to USC, and then the donation of that $100,000 to the United Way by USC. And it's important to note that that $100,000 donation was determined to be completely legal. The government acknowledged it, and there was an expert on campaign donations who testified that that $100,000 was completely legal. So just important that we get the facts straight. I want to ask you this, Mansfield. One of the arguments made by the government today in the motion for acquittal and the motion in the alternative for a new trial was, hey, the government said, look, everything, 99.9% of what the defense is arguing today were things that they should have objected to during the trial, but they didn't, and that they forfeited any opportunity now to bring those matters up before this court. What do you make of that argument?
Well, that's a legal principle, but factually, that's probably incorrect, because during the trial, the Mark Thomas's attorneys objected on many occasions to the introduction of evidence and asked for orders to cure what they thought were admissions of evidence that should not have been admitted. So no, I don't think that the prosecution made an accurate statement by making it appear as if the defense sat on its hands and didn't object during the trial. They did object numerous times during the trial at significant points where the objection would have had a material impact on the outcome of the case.
What do you say about that, Dion? You were in that courtroom every day of this trial. You heard every objection. You heard every ruling by the court on those objections. What do you make of the defense's argument? Hey, basically, these guys are a day late and $1 short when it comes to what they're arguing in their motion.
I agree with Mansfield, particularly with respect to arguments that Darylyn Dury was making today regarding the motion for a new trial, the Rule 33 motion. And one of the things she highlighted was the impugning comments that was made by the government during closing argument. Certainly, they did object to these things. And sometimes the judge actually made light of it and just would say, well, let's not impugn each other. And so I think it's the government's way of trying to pivot and put it back on the defense conduct and actions and things that they said that they are truly responsible for. Some of those things I found to be shocking, actually, during the closing argument.
All right, Bobby, now here's the big question, the elephant in the middle of the room. As I said earlier, these motions were made before the same trial judge that didn't rule on, made light of objections to the conduct that Dion just described. So now the defense is asking this same judge to reconsider her decision-making because the motion for acquittal was made at the end of this trial. So this isn't the defense's first, shot at this. They also, from what Dion told me, made a motion to dismiss at the end of the government's case, which is typically done. The judge denied that motion, said, nope, proceed on. This case is going to the jury. So now the defense is asking the same judge that ruled against them in terms of dismissing this case to now do essentially that, which is to dismiss the convictions and basically order acquittal on all counts, not just the 12 counts. How heavy of a lift is that for the defense team?
The defense is climbing up a very steep hill. As kind of Mansfield has pointed out in his commentary before, it's very difficult to get a federal judge to change their mind, especially given the fact that now this is going to be the third time that some of these arguments have been brought up in front of the same judge. The argument would be, why would she now change her mind on any of the things that the defense has brought up thus far? When essentially she had to consider everything, except for one point. Dion did bring up that she never actually ruled on one of the motions to dismiss. She just kind of let it go. And I think I had commented, well, the fact that she didn't say anything means that she ruled against you. But perhaps maybe that she'll take that into account in terms of reviewing some of the defense arguments. And, the main argument that we've all been talking about, that there just wasn't evidence presented on certain points that would lead to a conviction. I'm not saying she's going to do that. I mean, in fact, the odds are very much against her, dismissing this case or reviewing or allowing a new trial. But there is, some hope.
So, Mansfield, we know that the judge, according to what Dion, she and I had a time to debrief this morning before the show, and she told me that the judge listened very attentively, didn't ask a lot of questions, let each side lay out their arguments, said she would take it under submission. Help us understand what's going to happen next. You've been in this situation on numerous occasions. You've made these kinds of arguments before in cases. Help us understand the steps that will occur between this morning and before we are going to hear something from this judge.
Well, there are two ways to look at this. The judge could have ruled on the motions today. She's had the motions for some time. She's had her law clerks research the area, go back to the trial briefs. So she could have made a ruling today. So when attorneys show up at a motion hearing like this was today, and the judge then tells us that she's going to take it under submission, it sort of throws, we don't know which way now the judge is leaning. Is she going to take it under submission to make it appear as if she still is being justice is blind and she's going to consider it again? Or is she taking it under submission because she may have heard something in today's hearing that she may want to reconsider in arriving at a decision? We just don't know. But as Bobby said, and as Dion knows, this is an uphill climb to get a judge to basically rule against herself by granting any of these motions.
All right, when we come forward,
happen.
Yes, we have seen stranger things happen. When we come forward, I want to talk about this August date, because assuming this judge does not grant the request and the remedies requested by the defense, there's going to be something big happening in this case in August. When we come forward, I want to talk about that, and also want to congratulate Carol Fletcher. She was the second caller, and she is the winner of the KBLA swag bag. Thank you, Carol Fletcher, for listening to Areva Martin in real time and for listening to all the shows on KBLA. And thank you for helping us celebrate our second anniversary. When we come forward, more with my legal panel right here on KBLA Talk 1580.
This is a rather bold pronouncement, but we think we can back it up. If you come across a radio frequency anywhere putting more variety and more diversity on the air than KBLA Talk 1580, we sure would like to hear about your discovery.
You got to have vision.
You can search, but we are confident that you won't find more shows covering more topics, hosted by a more diverse and inclusive lineup of talkers than the squad we have assembled here at KBLA Talk 1580.
This is the time, brothers. This is the time.
We've got something for everybody.
That's right.
Health and healing, history and humor, issues and events, empowerment and entertainment, all in one station.
What's really going on?
Free enterprise, you dig?
KBLA Talk 1580.
Yes.
Oh yeah. We got a lot to talk about.
King Kong ain't got on me.
If you're not listening to Tavis Smiley weekday mornings on KBLA Talk 1580, you're missing out. Everybody wants to talk to Tavis.
That's one reason, by the way, why I'm so thrilled to have this conversation with you today. The three people I always most hoped would interview me were Phil Donahue, Studs Terkel, and Tavis Smiley. Donahue's retired, Terkel's deceased, so this is a real thrill for me. And the reason why I have such respect for what you do is you have a historically informed conversation of depth and detail.
Be sure to tune in to Tavis Smiley weekday mornings, 9 a.m. to 12 noon on your unapologetically progressive radio station, KBLA Talk 1580.
KBLA Talk 1580. Is the pen mightier than the sword?
They say the pen is mightier than the sword. At KBLA Talk 1580, we not only have a lot to talk about, we have a lot to write about. Politics, relationships, business, empowerment, and culture. The all-star roster at KBLA Talk 1580 has you covered.
That's what it's all about.
Be sure to follow us on all our socials for our latest book releases, op-eds, essays, and commentaries from our hosts. And, of course, download the KBLA 1580 app as we strive to remain your most trusted, credible, and reliable source for the issues you care about. This is unapologetically progressive. KBLA Talk 1580.
What up, baby?
I'm young, gifted, and black.
At KBLA Talk 1580, we do more than just talk.
Hey there, I'm Jared Hill, president of the National Association of Black Journalists of Los Angeles, and I just want to say thank you for the benevolent $10,000 donation and scholarships for the next generation of black journalists.
And I'm Haywood Galbraith, photojournalist and founder of the Minority Photojournalism Institute. Thanks, KBLA, for your generous $10,000 scholarship gift to help us train the next generation of black photojournalists.
Congratulations to all the students who will benefit from the scholarship dollars raised at our Black History Month luncheon, honoring black legends in LA media. When we come forward at KBLA Talk 1580, we're bringing everybody with us. Everybody with us. Everybody with us. Everybody with us.
Connection established. Access granted.
In a survey conducted by the public opinion research firm Uvidurus, KBLA Talk 1580 consistently emerged.
You're listening to Areva Martin in real time, and I'm your host, Areva Martin. If you want to continue to be a part of this conversation and other conversations related to what's happening around politics, race, and social justice issues, make sure you follow me on all social platforms at Areva Martin. I am joined in this hour. We have a couple of minutes left. I want to make sure we talk about what's going to happen in August as it relates to the federal bribery trial and now post-trial motions related to LA City Council member, former City Council member Mark Ridley Thomas. And I also want to just put in perspective again how incorrectly what happened in that trial and the convictions is being reported out by some major news outlets. One of the news outlets wrote, former council member Mark Ridley Thomas was convicted in March on federal bribery and conspiracy charges for steering county contracts to USC in exchange for admitting his son into a graduate program with a full scholarship and paid professorship. Ridley Thomas is appealing the conviction. That's wrong, people. That did not happen. That is not what he was convicted of. Another news outlet wrote, Councilmember Mark Ridley Thomas was convicted earlier this year of federal charges for trading votes during his time on the County Board of Supervisors in exchange for benefits provided by USC to his son. Again, not accurate, inaccurate, false, fabrication, sloppy journalism. Those charges related to trading on contracts to benefit Mark Ridley Thomas's son, Sebastian. Mark Ridley Thomas was acquitted on all of those charges. This case now is only about the $100,000 donation made by Mark Ridley Thomas to USC that was then donated by USC to United Way. And again, that $100,000 donation was determined to be a legal donation. And Bobby, I keep hitting on this point of accuracy in reporting. One, because it drives me crazy as a civil rights lawyer and as a journalist / talk show host. You know, I wear a lot of hats, but being accurate is important in so many professions. I would say all of them, and definitely the profession that we work in. And how important is this distinction that I keep making going to be if we get to the sentencing phase of this matter, which is supposed to be happening in August?
So you have 7 counts that he was convicted of. And so Areva, and I don't know if our audience knows that on the federal side of criminal justice, there's these mandatory minimums. So if you get convicted in federal court, they have guidelines that a federal judge has to follow with respect to sentencing. And depending upon what charge you got convicted of, there's a minimum floor and a maximum floor. It's a good thing that he was not convicted of all of the charges that he was originally indicted for. There's only 7 remaining. And if the action that was taken in terms of this contract, if the conviction is upheld and the judge ends up sentencing him for those charges, I would imagine that he would be sentenced toward the minimum range of the sentencing guidelines. And if he's ordered into custody, which because of the mandatory minimums, it's very likely he would be, it would be at a low-level security prison where typically non-violent offenders in the federal system go. So people who have done white collar crime, a big case that people know about, which also involved USC and UCLA, was the pay for play things that went on between coaches and people trying to get access for their kids to higher education, which included USC and UCLA.
Help us understand, Mansfield, what some of those sentences, if you know, were in the cases Bobby just referenced. And what's your estimation, again, if the motions filed by Mark Ridley Thomas's legal team are not successful, those motions that were heard today, we're waiting for a decision on those motions from the judge, assuming he's not successful, his team isn't successful, then we do move to the sentencing phase. What would you expect in that phase?
I would agree with Bobby that although there are quote unquote not mandatory minimums like there were before the Booker case, which basically now allows a federal judge to make a decision and look at the sentencing guidelines as recommended as opposed to mandatory. And because of that, I think the judge will probably look at the lowest of the lowest term sentencing that is possible under the conviction. But I don't rule out the possibility that Mark Ridley may never go to prison, and because there are other options available, house arrest, and he could wear an ankle bracelet, and that is done in the federal system when you get down to the low terms. He has no prior criminal history at all. He has a lot of bona fides. We know that this conviction will be set aside on appeal. The judge may know that as well. And so I doubt that he will get immediate incarceration. I hope that he isn't remanded. I doubt that should take place. But again, to agree with Bobby, I think it's going to be the lowest of the low-term recommended sentencing. That's what I think is going to happen.
I'm glad you mentioned.
See any prison time at all.
Mm-hmm. I'm glad. Thank you, Mansfield, for giving us that range of things and possible things that can happen. And clearly, when you have someone with the record of service that Mark Ridley Thomas has, we would expect to, and that's why that community support has been so important throughout this trial. We would expect the judge to take all of that into consideration. And you did mention house arrest, Dion. If and when Mark Ridley Thomas has to show up in court in August, he's going to be there on the same day that Marilyn Flynn, the former dean of USC's social work program, who's also involved in this case, someone who took a plea deal, is supposed to also be sentenced. We know there's a recommendation of house arrest and probation for her. What do you expect this judge to do, particularly if she agrees with the prosecution's recommendations for Marilyn Flynn to give her 6 months of house arrest, probation, or something short of, jail time, where she, as an 82, 83-year-old white woman, never steps foot in a federal prison? How might that weigh into what this judge does as it relates to Mark Ridley Thomas?
I think it will weigh heavily, Ariva. I agree with Mansfield. And I would also add that, part of the things that I would imagine she would consider is that given his ties to the community, he's not a flight risk. He's not an imminent or even low-key threat to public safety. And I watched her today with a probation violation where the government wanted the defendant, the individual on probation, to be remanded at least for 1 day. And it did help that probation wasn't supporting that, but she could have, and she didn't. So that gave me just a bird's eye view, Ariva, in how she is in terms of, in the moment of ruling on objections and things like that. I think that this case has been so interesting and probably unusual in terms of the evidence and the confusion by the jury that it's all there for her to do that if she's so inclined. So I definitely agree with what's been said here.
Real quickly, Bobby, do judges want to make examples? We know that we've seen, a list of folks who are in elected office who have been indicted, prosecuted, some convicted, none none of those cases in any way remotely related to Mark Ridley Thomas. No strippers, no casino chips, no private jets, no money in refrigerators or under, the bed, no money at all exchanging hands. But do judges want to make examples of high-powered folks who they think, might help their career in some way? This judge is probably at the tail end of her career, so I don't think she's thinking like that. But help us understand what judges are thinking when they are sentencing.
Well, judges primarily want to be seen as being fair, particularly on the federal side. They want to be seen as being fair magistrates. The problem here is she also doesn't want to be viewed as treating him differently because he's a political official. So his service is going to weigh for him on one side, but the fact that he's a public official is going to weigh on the other side. So you have two things that she has to balance. It's going to be a difficult decision for her, as Mansfield and Dion have laid out, but there's going to be a lot of pressure on her to sentence him to some type of time in custody.
All right, we've got to leave it there. Thank you so much, Bobby Grace, veteran prosecutor, Mansfield Collins, federal criminal defense attorney, and Dion Raymond, an employment lawyer and justice correspondent for KBLA. Great job as usual. Very enlightening, very, helpful information to our listeners, many of whom are really vested in this case. Our community is vested in this case, and I'm grateful that we're able to bring them up-to-date, accurate information about what is happening in that courtroom and what it means. We will definitely keep checking in with you as we get the order from the judge and as we move towards that August 16th date. If in fact that date happens, we'll see what this judge does, since she has these two very, very critical motions under submission. All right, guys, you can continue to follow me on all social platforms at Ariva Martin. I'll be right back here tomorrow at 4 p.m. bringing you trending news and my expert analysis. The next voice that you hear will be Robin Ayers and the Raw Report. Keep it right here on KBLA Talk 1580.
Gotta stay fresh, my house shot with a rest bar,
Have you visited us online for the grand opening of KBLA.store? For the best in new merch, gift ideas, books, media, and more, log on to KBLA.store. Be sure to check out our